trying to make sense and understand the Supreme Court process and what's happening next and things to look to as tomorrow sort of the actual dance actually starts and begin. But if I remember correctly, the last Supreme Court made a whole meal out of the process. And something to the extent that if the processes, election is not an event,
correct,
elections are processes,
yes,
right? And that still stands today.
Correct.
And tonight, where we see it is that last bit of the process is where the contestation is, if you like.
Yeah, it's important to know that although the court said that elections are a process, the court is not reviewing the entire process. The court is reviewing such part of the process that the parties themselves have taken issue with. Because courts eventually are bound by what parties come before it and do what you call pleading, what they claim and what they ask from it. If you study these petitions very well, apart from one of them that raises issues about the voters register, but when I looked at the issues, I kept wondering how that fits in the scheme of issues as framed. These issues have to do with the very last phase. How are these results transmitted from the respective polling stations, and how are they tallied at the National Tallying Center, and the final declaration or decision to declare and the declaration itself made. So that's the focal point of the petitions that are before the court. So it's that part of the process that will be of great interest to the parties in this process. And my reading of these issues is that the court is interested in understanding significantly the integrity of the technological system,
right.
The integrity, what security was put around it. Was it immune from mischief? Was it sufficiently immune from mischief? The way this should have been framed lead me to that conclusion. That's what the court will be looking at. So that as the parties spend their 3 or 4 hours, whichever hours they've been given, the more the energy they spend on that issue, the better their chances from the way the issues have been framed.
Mm-hmm. Mm-hmm. Prof.
Back to this question of process. I think we go back to the 2017 decisions. You compare the majority decisions and the minority decisions. And what was interesting about the majority decision is that they set a very, let me call it a low threshold. Because they said that if we find any kind of violation of the Constitution or the law, we will nullify the election. And that was a test that was set in the Karanja Kabagi case. It's a very low threshold. Any violation we will not tolerate. Will be intolerant of any violation. As you can imagine, you're bound to find violations of some kind. The minority, on the other hand, was saying that is an extremely demanding task to ask of the IEBC. Inevitably, they're bound to be a violation here or there, but one then needs to look at the impact of those violations. So if they have no impact on the outcome, then surely, I mean, the human foibles will say that these things happen, but as long as they don't fundamentally alter the outcome, then these are things that we can't tolerate. So it will be interesting to see how the court then approaches that question. Is it going to approach it the same way as it did in 2017 and say there is zero tolerance for violations,
right?
Or is it going to have a bit of tolerance? Looking at it just from the view of the process.
Yeah, I mean, I know you're both teachers of law, and maybe this is a question